expend that just to, quote, set it for a hearing. When if it's going to end up, if somebody did something, they need to take responsibility for it. It goes over so much more with me, I think with the state, with probation, and it should be something that someone is encouraged to take personal responsibility instead of saying, let's see if they can prove it.
If I might, I'll try to address that in the future.
I appreciate
I hate
it.
him to be warned about something that I probably didn't.
I mean, you've been on probation for so long to be making these kinds of mistakes. You know, I could revoke you right now and send you to prison for 20 years. That's how serious this is.
Mm-hmm.
It's not a game. And I know you've been on it a long time, but, I get the whole argument, smoking marijuana is not that big of a deal. Well, it is if you're on probation.
It wasn't like that.
Well, you got arrested.
No, I'm saying I made a mistake, but it wasn't, I don't just smoke weed,
Well, but you have, because you've tested positive a few times. So I understand that maybe you don't all the time like some people, but you have. And you got arrested for it, for having it. And so here's what I'm going to do, Mr. Ellis. And I want you to take advantage of this because after all this time, you don't have the conviction on your record. You're about to get the opportunity of a lifetime. You've already gotten a huge opportunity. When I do things like this, what I'm about to do, and you don't take advantage of it, it is typically going to be a whole lot worse than if I were to just revoke you today. So I want to make sure you understand that you're being given an opportunity, finish this probation, and hopefully not have any more issues because it's going to be very serious if you don't. So I'm going to find that you, again, entered your pleas of true to counts 1, 3, 5, and 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty, and revoke the probation. I'm not going to do that. I'm going to extend it that last year that we've got to extend it. So you've got one more year. You will be on the drop program, so you'll be tested more frequently. You're going to be on the high medium caseload, which means you'll have to report more frequently. That's the price you pay for getting in trouble, but it's a whole lot better than going to prison and having the felony conviction. If you do everything like you're supposed to between now and the end of that next year, you're off probation. If you don't, you're in prison. All right. Any questions?
Okay.
But will the court also order the MRT class that you had mentioned?
Yeah. So the MRT class was already ordered. I want that started within 30 days.
Yes, ma'am.
So you need to get a job if you don't already have one. You need to do whatever you do to buy that book. I want that class completed. No questions asked. I don't want you waiting to the last minute. It's 18-week class. I want it started within the next 30 days. That's in order. You understand? If you have any questions about any of your other conditions, don't wait for probation and then say, well, they didn't tell me something. Go say, am I doing everything I'm supposed to be doing? I don't want to go to prison. All right, you're Malik Ellis. And Mr. Ellis was previously in court in cause number 1726733, entered pleas of not true and a motion to revoke probation. It's my understanding that we're here for sentencing. I've gotten the pre-sentence report, but it's my understanding that he's going to enter pleas of true to some of the counts as change his pleas. Is that correct? And so will he waive the formal reading of that motion again?
So
let's go through the motion again. Mr. Ellis, so it looks like before you pled true to counts 3 and 6, and you're on probation for the second-degree felony offense of aggravated assault with a deadly weapon. That was a 7-year deferred probation that was extended for 2 years. Let's go back. Count 1 alleges that you committed the new offense of possession of marijuana, a Class A misdemeanor on November 18th of 2025. And is that true or not true?
True.
Count 2 alleges that you failed to report to the probation officer your change of address. Is that true or not true?
Not true.
Count 2 is not true. Still. Count 3. making the modification here on the agreed punishment recommendation, Mr. Kimler, y'all wrote in 2, but he pled not true to 2 just now. So I'm
There
gonna,
wasn't.
He was going to.
on which counts he was gonna plead true to, y'all
Everything.
wrote in 2, I'm marking through 2 because he pled not true.
And I'll put on evidence of that for the court judge.
Okay, and then count 3, he already pled true to. Count 4,
We abandoned, Your Honor.
state abandons. Okay, and then count 5 alleges that you possessed an illegal drug, namely marijuana, and that you were in possession of it November 18th of 2025. Is that true or not true?
True.
And then you already pled true to count 6. So today you've changed your pleas and pled true to counts 1 and 5, and you do that freely and voluntarily.
Mhm.
And did you plead true to counts 1 and 5 because they're actually true?
Yes.
All right, then at this time I'm going to find counts 1, 3, 5, and 6 true. And Ms. Malfino, you have evidence with regard to count 2?
Very briefly, Your Honor.
Yes, ma'am. And would you please raise your right hand, ma'am?
Yes,
Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And if you'll just state your name for the record, please, ma'am.
My name is Shay Kane.
Thank you, Ms. Kane. Go ahead, Ms. Malfino.
Thank you, Judge. Ms. Kane, would you please identify what you do for a living for the record?
Yes, ma'am. I'm a community supervision officer for the Jefferson County Adult Probation Department.
And how long have you been with the department?
I have been with the department for a year, but I've been a probation officer for about 3 years.
And do you have occasion to know a Malik Jamal Ellis?
Yes, ma'am.
Do you see him in the courtroom today?
I do.
And is he one of your probationers that you supervise for this court?
Yes, ma'am.
And as a condition of that supervision, was he read all the rules and conditions, gone over those with him of what the court expected his behavior to comply with while on probation?
Yes, ma'am.
Was one of those that he at all times provide you with an accurate address of a residence and location of his job, et cetera, so that the community supervision department and thereby the court could find him at any time?
Yes, ma'am.
And if he changed this address, was he told or informed that he needed to indicate such to the probation?
Yes, ma'am.
Based on your review of your file and your contact with Mr. Ellis, the defendant, did he change his address and report such to you?
According to the offense report that I received on November 18th,
Hang on just a second. It's okay. We'll just wait till he calms down a minute. Maybe they'll come get him. All right, go ahead.
according to the offense report I received on November 18th, it had appeared that he gave the officers a different address on the report itself. And based on that, he had never told me about any different residential since I've been supervising him.
And based on your supervision, you also became aware that he was arrested and has now pled true to possession of marijuana back in November of 2025, correct?
Yes, ma'am.
Would this have been obviously in violation of his probation?
Yes, ma'am.
And in discussions between you and I last week, we decided not to bring a lab analyst to prove that up, even though we have the Trooper Lucio here in court today, based on the fact that 2 days later, he tested positive for shedding marijuana, correct?
Yes, ma'am.
And do you have some other thoughts that you would like to share with the court at the appropriate time with respect to what your position is as to continuing him or revoking him off this probation?
Yes, ma'am.
And can we hold on that for a second?
Yeah,
You do
yeah.
have additional for the
Yes,
court.
ma'am.
And Judge, I'd like to just wait following cross-examination, also ask at the appropriate time that with the thanks of the state, the trooper be released this morning. He's here in court.
Any issue with the trooper being released? Thank you so much for being here, sir. You're free to go. We appreciate you.
Thank you, Judge.
All right, Mr. Kimler, do you have any questions of Ms. Kane?
Just want to be clear. So he filled out some paperwork and listed an address that was different to the one he reported to you.
It appeared that he told the officers at the time he was arrested, what I read on the office report, it was a different than what I had in my system. It was 845 Madison that I had, and it was a different address listed at the time he was arrested.
No further questions.
All right. No, ma'am, we're not. All right. Any other witnesses then?
I don't believe so. I'd like to cross-examine that witness if they're called, but
Yeah.
I think I know where that's going.
Okay. Do you intend to call any witnesses?
So I guess I can call Grace. She wants to talk, so.
Well, I mean, is it
Let's look at it like I should.
No, go ahead.
with regard to what issue?
Where's your grandmother?
Oh, she was just there for the change of address part. She just there for support.
Okay, that's fine.
What explanation? I'd call Mr. Pelletin.
Raise your hand. Well, did they already swear you over here today? All right, go ahead.
What explanation do you have for the difference in the addresses?
It must have went out my ID. My ID say my mama address, but I stay with my grandmother. When they came to pick me up from my warrant, they picked me up at 845 Madison. They said,
Okay,
But your driver's license, your ID says what?
4751 Elden Road. That's my mother's house.
okay,
But that's not where you
I
stay.
stay with my grandmother, which is the house that's on fire.
okay. You know, it's a law that you change your license when you
I
Move.
ain't know what-
So you can see the kind of issues that gets you in if you don't.
That's my-
Right. So it's very important that you take care of that. All right. Anything else with regard to the actual counts?
Not from the state.
Okay. Then at this time, I'm going to find
Yeah.
counts 1, 3, 5, and 6 true. Find sufficient evidence to find Mr. Ellis guilty. Mr. Kimler, what is your position with regard to punishment?
Well, Your Honor, this is from 2017, so I guess he's been on probation. I'm approaching 10 years, perhaps. I think it was extended one time. Obviously, he's had issues on probation. This latest one having to do with marijuana. I would just observe that he was negative today in court on the drug test. I guess he has at least refrained from using marijuana since this last incident and the last time he was tested, and tested positive. The court, as it's presented, has the options, is presented to either keep him on probation or let him discharge or revoke him. I think there's a middle position where he could be unsuccessfully discharged from probation without being revoked. That may be an option that the court would explore instead of having just at the end of this period of time revoke him and send him to the penitentiary. There's an option to unsuccessfully discharge him from probation. And that would be what I would suggest if the court's inclined not to let him to sanction and not let him stay on probation, but to unsuccessfully discharge him from probation in lieu of revoking him and send him to the penitentiary. Is there anything you want to tell the judge?
How long? Hold on. What's the time frame on getting the MRT class done? How long is that?
How long is it?
Process.
It's about 18-week course. It's in the probation office itself.
How many weeks do we have left? Is that something that if could he get started on that next week? If that's, I don't know if that's where I'm going, but
Yes, ma'am.
hold on.
We would just have to buy the book, and so we can get him into the program.
Ms. Malfina?
Judge, I would defer to anything Ms. Kane has. We've spoken multiple times about the case. I know she's tried everything. I'd just like her to let the court know her thoughts.
Well, we can't extend again, can we? Or is there any time frame left?
So he's at his 9 years
So we could do one more.
at the very, yes, ma'am. That would be the max that
Gotcha.
we have left.
Okay.
And he has also been to ISF cognitive track as well. But as far as what I would possibly recommend would be to put him on the high medium risk caseload for the rest of the entirety if the court allows, zero tolerance, and possibly place him on the drop program to continue the more in-depth testing if the court would allow.
Sorry.
Anything else? Ms. Malfina to add to that?
Judge, I don't have much. Of course, I would defer to Ms. Kane and the court. Obviously, the state is somewhat frustrated with Mr. Ellis not taking initial responsibility. That's what I think people should get favor for instead of having to trooper have to be here, and thankfully we didn't have a $3,000 plane ticket for a lab analyst to then what he then wanted to come in and admit. I would have rather him taken responsibility, and I don't say that in the context of disavow him of his rights to contest it. It's just that if he's
No, it's
not,
a very frustrating
if
thing
he's
for
not
me
being
as well. And
forthright with
it's,
the court, should he have the benefit of the continuance on probation? Is all, not in the context of a not true. I understand that.
I wouldn't take the blame for that if I'm not, Your Honor, in a way, in dealing with these cases that I perhaps advise my clients.
I know that's something probably needs to be addressed. We've talked about recently on several of them because it's very frustrating to have people come and take time out of their day, out of their work. The state have, okay.
One person.
What's that?
On the fees, but what am I supposed to be paying? Cause I keep paying
I don't-
supervision for you.
So here's the thing, talk to them. They can explain to you, there's different, you had fees, you have fines, you have different parts of that. You're supposed to be paying it all. And certain things that you pay go to certain parts of that. And they'll put it towards different things. Talk to your Miss Kane will explain to you what you've paid, what it's gone to, and what you still owe. Okay? But just ask her. All right? Okay. You're free to go. Thank you.
That's all. Thanks.
That cup is like that. You can pull out these out.
They're on Toy Frazier, Mr. Gertz. Are y'all doing paperwork?
Miss Alvino has been otherwise occupied, but
I don't need to sit with that.
Like that.
Get there with that before I sign it, but I do. Let Judge know.
he's already signed the thing, hold it.
Okay, I'll just ask for a little bit of it and
Right.
What the appellate,
Did you send me something on that? I'm sorry. I didn't-
yeah, I sent the appellate certification.
It's here. I've got it. Mr. Nichols, it goes straight here. All right, so are you Angel Mata Rodriguez?
Yes.
And will your client waive the formal reading of the motion?
He will.
Mr. Mata Rodriguez, in cause number 23, DCCR 1106, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation November 13th of 2023 for the third-degree felony offense of evading arrest or detention with the use of a vehicle. And that was a 5-year deferred probation. Is that correct?
Correct.
And it alleges that you violated your probation. Count 1 alleges that you committed the offense of driving while intoxicated with an open container, March 22nd of 2026. And is that true or not true?
Oh, true.
I'm sorry.
True.
True. Count 2,
We just want to award it.
not if it's unagreed.
Oh, okay. That's true. You're right. Sorry.
Count 2 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you became intoxicated March 22nd of 2026. And is that true or not true?
True.
And then count 3 alleges that you are behind in your court assessed fees as of April 29th of 2026 in the amount of $710. And is that true or not true?
Oh, not true.
Okay.
No, it's as of that date, not now.
Oh, other day. Okay, true.
It was true as of that day. Okay.
Yes.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Correct.
And did you plead true to those counts because they're actually true?
Correct.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. But I'm going to reset your case so that the probation department can do an updated report, and we will come back for a sentencing hearing. Anything you think is important for me to know, be sure and get that information to Mr. Kimler. He'll present it to me on your behalf when we come back for sentencing.
Yes, ma'am.
And make sure do you need to talk to him today? Okay, just stay in touch with your probation officer. Yes, sir.
I have one question. I know I have the ankle monitor. Is there any way I can get a patch instead of monitoring?
The patch doesn't do alcohol. Yeah, so that's why you've got the SCRAM device on, is because that's the one that tests for alcohol.
Okay.
Okay, so at least until sentencing, we're going to keep it the way it is.
Yes.
Okay, all right, we'll see you back at sentencing. So why'd y'all do paperwork on Malik Ellis?
It's unagreed. There's one counts.
I know it's for sentencing, but I see the paperwork.
Yeah, I just did it. He's pleading open.
He already did. We're here for sentencing,
No, that was when we ran to the hearing.
but he already entered his pleas. It's just a hearing on sentencing.
He pled not true, though. He's pleading, he changed the plea to true.
I think
Okay.
he did the paperwork because he's changing the not truth to truth.
Thank you.
Yeah. I just did it.
That's nice.
Is that the same one?
Appellate certificate is in there too.
So it's now agreed?
No, it's no agreement. He's just pleading true, pleading open.
Gotcha.
He's not happy, Judge.
You could have fooled me.
I just want to keep you informed.
Thank you very much for that information. Well, which makes it all the more believable that he was not nice to probation. You know what else I want on him? Riley? Riley or Riley?
Riley.
Yes, ma'am. For sure. And substance abuse and assessment as well. Yeah, he admitted to at least marijuana, and there was some talk about fentanyl as well. So I want substance abuse as well as mental health. And he smoked last night, so I'm not sure if there's something else going on that has to do with that as well. So, all right, Malik Ellis. Okay, I forgot to know this. What did you just put true to on that other one? Thank you.
I think how you just made it.
We didn't even talk about it.
All right, are you Toy Frazier?
I can deal with restitution.
And lawyer client with the formal reading of the indictment?
I will, Judge.
You might.
You put this on third degree paper, right?
Yeah, you want it on.
You were our oh, so we're not worried about we have public studies. We're just doing this. Okay.
Yeah.
We can.
Okay.
Okay.
This is the.
Okay, we're going back to the original.
Leading to the indictment.
Got it.
Yeah, sorry. So when I did look, I put it on.
I saw it.
Sorry, Judge. He had made a counter. I thought that's what the paperwork was supposed to be to, which it is not. So this is the original.
I need to, he's gonna have to be
And-
sworn in, as soon as that goes through, step in front of the clerk. And are we going on count one only or no?
Yeah.
Yes. Just based on the nature. And why I said, Judge, if you have anything at sentencing, it's involves the assessor collector's office. And
Okay.
if they have some thoughts to add, I would ask for a little leeway at sentencing on that. Yeah.
And we also will need to establish a restitution amount, but it's just for limited to 3. Even though it's only one case, it's limited to 3 things in discovery. So
Okay, that,
We
make
need
sure
to understand.
probation, yeah, make sure probation understands
that's
as
a
well.
other component that we just need to get on the record too. It'll be in the paper.
No birds. The several way to do the discovery verification.
It's my first day.
That's what she said, was just started. It's this new thing. Okay, and so will Mr. Frazier waive the formal reading of the indictment?
He will, Judge.
Mr. Frazier, in cause number 25, DCCR 1494, the state has elected to proceed on count one only. It alleges that you committed the third-degree felony offense of giving a false name or forging a vehicle registration from July 6th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
I did.
Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Nice.
And it looks like the agreement is for a 2-year deferred probation. There would be a $750 fine. There would be restitution. It says for sales tax, and that would be, you guys can work that out with probation, and we'll get that amount of restitution when we come back for sentencing. Also, this has an agreement that you would be able to travel for work. I do want to make sure you understand that that's not just a blanket. You can travel without letting probation know. You're still going to have to get permission to travel. My screen just went black. I'm sorry. You still are going to have to get permission, or at least let them know job dates, things like that. Okay. It's not just a blanket. You can go wherever and we don't know where you are. Does that make sense?
It makes sense.
Okay.
And Judge, that was an important point in our negotiations, that he'd be required to communicate where he's going, but wouldn't have to come to the court every time. And
Well, you don't have to come to me, but you have to go to probation.
and just
So the permission to travel typically comes from probation, unless there's some issue and they say, well, you don't think it's a good idea. So you still have to go through that. I'm saying now that I want you to work. And what's the job?
I go to auctions, and that consists of going to different states. Like, so when you win a vehicle, you have 48 hours to pick it up, and I have to be there, pick it up. It's a daily fee if you're not there on time.
Okay. So I'll look some more at that at sentencing. Is this that I just feel like that's kind of something that has to do with the underlying offense, and that gives
And
me
we
some
made it
concern.
very clear that it would require the okay of the court, maybe not in person, obviously present here, but
Right.
it would.
So, I mean, you're going to have to, 48 hours means you're going to have to get with your probation officer and have that understanding that you're bidding on whatever the process is. It's, you have to have that permission before you go. All right. So if it costs money, whatever happens, you cannot go out of Jefferson County without probation giving you that okay. I'm telling you it's going to be okay, and you don't necessarily have to get my permission, which obviously would take much longer. You have to be in constant communication with your probation officer, more so than most people, because this is your job. And if you want to be able to do it and be on this probation, you're going to have to take those extra steps. Okay. All right. State tenders number 1.
we have no objection, Judge.
It's admitted. Is there any evidence that Mr. Frazier is not competent?
None at all, Judge.
All right. So I'm going to find, and you're a U.S. citizen, correct? I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get the probation department to do that pre-sentence report. And then we'll come back later for sentencing. They'll get the restitution figured out. Go ahead and visit it with. Is that he failed to provide and maintain accurate residence address with the probation office. 6 is that he failed to provide verification of performing community service hours. 7 is that he was at a location other than his residence after curfew. And then 8, which is one he pled true to, was fees. And so y'all remind me, we're here. Ms. Malfina's state has witnesses with regard to at least some of those. Is that correct?
Yes, Judge, I would ask, please, that the court take judicial notice of the original PSI and cause number 23, DCCR 225. I have a hard copy here for the court if you'd like to review that.
Let me, should have it here. I've got mine. I'll print it out. It's got my notes on it as well. So
And also, Judge, just to refresh the court's memory, this was set last week. We had a corresponding officer, for lack of a better term, that was going to be here on another hearing today. So I asked the court to put this today just because that officer who works graveyard is going to be here already. That case has since been moved to a later date. The arresting officer in this case, the one named in the new evading officer laws, possibly due to no fault of his own. I just want to make it clear that it was me who requested this quick turnaround and probably inconvenience to everybody. So that's totally on me. We've been unable to reach him. My investigators have made several attempts. He is not here today. Again, I'm not pointing the finger at him because he may have had an extended time period off. I just have made every effort to have him here today, but have been unable to have his presence secured for this hearing, Judge. But I do have Ms. Lopez from the probation office based on the fact that there are several administrative violations that she can go over that have been pled not true to, and also to get her thoughts for the court's input. We will either let the new case rise and fall on its own, depending on the court's decision, or take some appropriate measure with respect to your decision to satisfy that case. For example, if it's ISF or something like that, of course, we would dispose of that case in a manner that would allow him to go on to ISF timely. So that's kind of where we are. Again, I'm not blaming the officer, but we've made every attempt to reach him and have been unable to do so. So I don't have a lot for the court, but that's what I'm doing.
So I guess a couple things we could do. I mean, obviously the other allegations are important, but that's the main allegation. And so we could start the hearing. I could hear the evidence, and then we could recess the hearing and see if we can get him here. I'd like to have that information. I think it makes a big difference primarily because what he's on probation for is evading arrest with the vehicle, and the new alleged offense is another one. And so I think that is a serious enough allegation of the same sort that me just making some decision because there might be some possible missed communications, not necessarily missed communications with the officer to get him here. I think it's obviously very important that we get him here. And so I think I'm more inclined to listen to what everybody has, make some notes, and then hold any decision, reset it a week or two at the most. And I want to have a hearing and if it's just him, it may be something that we can do on a regular docket at the end of the docket.
Yes.
So, all right. So let's go forward with what you've got. Then you may call your first witness.
Thanks. I will call Ms. Lopez.
Good afternoon, ma'am. If you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can have a seat.
Thank you.
You may proceed.
Judge, Ms. Lopez, please state your name for the record.
My name is Raquel Lopez.
And how are you employed?
I am a probation officer with the Jefferson County Probation Department.
And as such, do you have an opportunity to supervise an individual by the name of Accordion Dion Guillory?
Yes.
And do you see Mr. Guillory in the courtroom?
Yes.
Please point to him and identify what he's wearing.
He is at the defendant's table in a gray sweatshirt.
Your Honor, may the record reflect that Ms. Lopez has identified the defendant.
The record will so reflect.
And Ms. Lopez, obviously everybody is aware for purposes of this hearing, the nature of probation and what rules and regulations individuals are ordered to follow based on this court's probation is to commit a new offense clearly against the rules of probation.
Yes.
We have alleged in the motion that Mr. Guillory has committed the offense of evading detention in February of 2026.
Yes.
And it is also the underlying type of offense for which he's in probation and has been on probation for only 1 year.
Yes.
With respect to that, do you have any additional evidence based on your own knowledge or review that you would like to impart with respect to that abating, or should that better come from the officer who stopped him?
It should better come from the officer because the only thing I do have is the officer's report from that evening.
Okay, and in that context, it was reported, and in fact, Mr. Guillory has pled true to the fact that part of that offense involved his being in Harris County, correct? At some point in time, either purchase a vehicle, some point in time, would that in and of itself, which he has pled true to, be a violation of his probation?
Yes.
Was he also ordered as a condition of this court's probation to work faithfully at suitable employment and provide you verification of such?
Yes, he was.
And has he done that?
No, he has not.
And that is in violation of his court order of probation, correct?
Correct.
And in the same context, has he failed to provide documentation verifying the source and amount of his income, most specifically related to a 2025 tax return?
Yes.
And did you ask him to provide you this information?
Multiple times.
And he did not.
Correct.
And would that have been in violation of his court order of probation?
Yes.
Was he also ordered by this court to provide and maintain an accurate residence address with his officer so that you or this court could locate him at any time?
Yes.
And did he do so?
He provided me an address at each of his office visits, but when he was questioned by the officer in the officer's offense report, he gave a different address.
Objection, hearsay.
Overruled.
So you had the two addresses listed in the motion, correct? The
Correct.
address there at Rusk and the address on West Lucas.
Correct.
And pursuant to the totality of this motion, came to your attention that yet another address for Mr. Guillory, which you did not have, had been associated with him.
Correct.
And again, it's just important that you have that information so that you, any of your officers or the court could find him at any time
Correct.
for a home visit or any other reason.
Correct. Or for instance, if I need to reschedule an appointment, I'll send a letter to that address, the address that I have, so that they know, that by no fault of their own, I'm needing to move their appointment.
Correct. And was Mr. Guillory also ordered as a condition of this probation to perform and give you verification of performing community service hours?
Yes, and so this should be noted that Mr. Guillory had previously performed community service, and then he started to have some violations. And so within our office, we have the option to reinstate previously waived community service hours. That's part of our community service amendment, is that when we ask to have community service hours held in abeyance, we have the ability to reinstate hours should we feel the need to. And so due to Mr. Guillory not doing what he was supposed to do, my supervisor chose to reinstate 50 hours of community service. And he has not completed those 50 hours.
Okay.
That's the 50 hours that we're talking about.
Okay. So although he has done some, there were violations that as a sanction thereof required reinstatement of some of those hours which he has failed to comply with.
Correct.
Curfew is a condition of probation, correct?
Correct.
And was he in violation, according to your review of all the documents of that curfew on February 27th of 2026?
Yes.
And would this go hand in hand with what he has previously pled true to as to being in Harris County?
Correct.
And lastly, he was court ordered to pay all the required fines and fees directed by this court with respect to his probation. And has he done that, or is he in arrears, or has he been in arrears at some point in 2026?
He is in arrears currently $2,202. He has not made any form of payment since January of this year.
And additionally, absent anything that Officer Moss or any officer from Beaumont Police Department would have, is there anything that you would like to add for Judge West while you are hearing under oath on this case?
Additionally, I was not able to check GPS tracker. He's on bond for his current case. And one of the conditions is that he have a GPS tracker. I was not able to check that last week because I was out of county in a training. But when I checked today, it was found that he was out past curfew on July 4th.
And had you been in the office last week,
I would have been able to check more accurately before today, and would have been able to submit that to the court sooner, but I only returned back to the office today.
this morning, right? And had I not requested this hearing so quickly, in the ordinary course of business, the court could have anticipated us filing the First Amendment.
Correct. And I do have documentation of that from the GPS tracker website if that's needed.
Thanks, Kathleen.
Thank you. Mr. Kimler?
Good afternoon.
Good afternoon.
You say it was out past curfew, the GPS indicated it was out past curfew, the
Correct.
24th.
Correct.
What was the address that that's taken to be able to stay in his office?
If you use it as 2120 Ashley Street of Beaumont, Texas,
And is that the address that you've had for him throughout his probation, or has that changed?
that's changed.
When was that updated?
His GPS, the address that he has for his current GPS is a Longfellow Avenue. And then he was at 2218 Rusk Street before that.
So Ashley is the current address that you have for him? Or
No, Ashley is the address he was at when he was in violation.
My question was, what was the address that you had for him as his residence location?
2218 Rusk Street.
That would have been July 4th, is that right?
No, he had it as a Longfellow. I don't know the exact address for Longfellow.
So what is the Rusk address?
The Rusk address is where he lived before he was on GPS. He told me at his last office visit that he has moved into the Longfellow address since he's gotten the GPS tracker.
Back when the allegation is that he didn't provide you with the proper residence address, what was the address that you had then?
Then it was 2218 Rusk Street.
Rusk. And the address that he provided to law enforcement is indicated by the report.
Can I look at my
Yeah,
report?
sure.
Because I admittedly don't have that memorized. That address he gave was a 2450 West Lucas Drive, apartment 37.
Was that where he was located when the officer encountered him?
I'm not aware of that.
Do you know, I guess the allegation would be that would be the address he was living at, and that wasn't his current address?
Correct. That was the address he, at least according to the offense report that I have, he told the officer that was where he was living
Right.
at that time.
And we maybe can take that up with the officer. Do you know have you ever reviewed his state issued ID or driver's license?
He does not have one.
Okay. Do you know the address that he was booked in the jail under?
I do not.
Have you ever had mail returned to you from the Rusk address or not?
I do not believe so.
Did you ever do a home visit there? Was he there?
I have not.
So the allegation that he didn't give you the correct or didn't update his residence address is predicated on the address that he gave to the officer. Is that
Correct.
Nothing else?
Nothing else.
How far behind is he on community service? 50 hours?
50 hours. Yes, sir.
And as far as maintaining suitable employment, he never provided any kind of proof that he was employed?
He has told me throughout his probation that he is either looking for employment or he is doing side jobs, but he's never given me any proof of that in regards to hours logged or anything like that. And as far as actual gainful employment, I've never received any form of paycheck stub or anything of that nature.
Any kind of any indication that all days employed at all has been provided?
Not as of this filing.
Suitable employment, I guess, means legitimate legal work.
Something that you can file your taxes for.
Yeah, 1099s.
Yeah. Correct.
Passwords.
Ms. Malfino?
I don't have anything additional. Judge?
Thank you, ma'am.
You can bring it up.
All right. Any other witnesses?
Not from the state judge, the court will indulge us with respect to Officer Moss. I will make every effort to have him here either tomorrow, Monday or Tuesday of next week.
Yeah, let's do this. Let's I would rather go ahead and make sure I don't want to set it for tomorrow and then you not being able to get in touch with him. So let's do it next Monday. At the end, the 10 or 11 o'clock once we're finished with the docket.
You want him here?
9 o'clock. I want you here at 9 o'clock next Monday morning. and get in touch with Officer Moss, and we can go through what we need to at the end of next Monday's docket. And but before, do you have any evidence then with regard to Mr. Kimmler, with regard to any of the other? You don't have any witnesses with regard to the administrative stuff that Ms. Lopez?
I would call it for explanation, Your Honor, but would rather call him after the officer.
Okay, so we'll take care of that at all at that time.
Be very involved in that.
Okay, so just to make it, I want to make sure so that if for some reason Ms. Lopez cannot be here, at least for the address. And I'm taking judicial notice of the court's files in both cases, and y'all can figure out where this all came from. But I do have the probable cause from the new offense, and the address on that was either given or given in some type of ID form was the 2450 West Lucas. And the address that you had, Ms. Lopez, was the 2218 Rush Street. And then the curfew from July 4th, which, do you guys have what I'd like between now and next week? If there's time, do y'all have time? If there's going to be that allegation, if y'all want me to take into consideration an additional curfew violation, get that administrative done very quickly. Can you get that motion amended before next? Are you okay going forward next Monday with that addition? So if y'all can get that done, then we can definitely, I can take that into consideration, and you can talk about it with whatever you need to with regard to the curfew and the GPS, and get those documents, if you would, to Ms. Smallfino so she can make sure that Mr. Kimmler gets to take a look at those GPS documents. Okay, so what I'm going to do then is recess this hearing until next Monday during our docket. Be here at 9 o'clock, but we'll do it once we have a break that's sufficient enough. Ms. Smallfino, if you find out for some reason from the officer that he cannot be here, or refuse, if you need my help on anything, let me know. Okay, thanks. Defense counsel are present. Everybody's been given a copy or emailed a copy of the court's proposed charge. Any other additions or corrections or objections to the charge?
I'm going to say, Judge.
No objection, Judge.
All right, then, how long would either of you want me to give you a heads up on time?
2 minutes, Judge. I'd like 2 minutes total, Judge.
Okay, you good with, I'll let you know if you start going too long. You can bring the jury in. Hey, Tommy and Tom.
Still many times.
On your last page. And I'll print that. All right, let the record reflect the jury is seated. State attorneys present, defendant and defense counsel are present. And ladies and gentlemen, at this time, just like before, I'm required to read the court's charge to you. Cause number 25 DCCR 0963, the state of Texas versus Asa Joseph Jones, jury instructions. Members of the jury, you have found the defendant, Asa Joseph Jones, guilty of the offense of aggravated assault. Now you must determine the punishment to be imposed on the defendant. The parties will soon present final arguments on punishment. Before they do so, I must now give you the instructions you must follow in determining the defendant's punishment. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will tell you about the specific law applicable to this case. Finally, I will instruct you on the rules that must control your deliberations. General principles. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. In determining the sentence to be imposed on the defendant, you may take into consideration all the evidence admitted before you. This includes the evidence admitted during the first stage of the trial concerning the defendant's guilt, as well as any evidence admitted during this punishment phase. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. To request that testimony be read back to you, you must follow these rules. The foreperson must make the request in writing and sign it. That request must 1. State that it is requesting that testimony be read back. 2. State that you have a disagreement about a specific statement of a witness or a particular point in dispute. And 3. Identify the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that's in dispute. You must arrive at the amount of punishment by a fair, full, and free expression of the opinion of the individual jurors. You must not decide the punishment by lot or by chance. For example, you may not agree beforehand to be bound by the result of a procedure by which each juror gives the number of years the juror thinks should be served. These are then added, and the result is divided by 12. To reach a verdict, all 12 of you must agree. Rules that control deliberations. You must follow these rules while you're deliberating and until you reach a verdict. After the closing arguments by the attorneys, you'll go into the jury room. The foreperson should conduct the deliberations in an orderly way. Each juror has 1 vote, including the foreperson. The foreperson must supervise the voting, vote with other jurors on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1. You must not discuss this case with any court officer or the attorneys or anyone not on the jury. 2. You must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, you must stop your discussions about the case until all of you are present again. 3. You must communicate with the judge only in writing, signed by the foreperson, and given to the judge through the officer assigned to you. 4. You must not conduct any independent investigations, research, or experiments. And 5, you must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Sorry. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your foreperson sign his or her name to the particular form that conforms to your verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. The defendant has asked that you recommend he be granted community supervision. You may, in this case, be able to recommend that the confinement assessed by you, any fine assessed by you, or both be suspended and the defendant placed on community supervision. Community supervision is often called probation. The two terms mean the same thing. If the defendant is placed on community supervision, the defendant will not be required during the period of community supervision to serve the period of confinement assessed by you. If you assess a fine and recommend that the fine be suspended, the defendant will not be required during the period of community supervision to pay that fine. If the defendant successfully completes the period of community supervision, the court will discharge the defendant. A defendant so discharged will never have to serve the confinement assessed by you or pay any fine that you have recommended be suspended. During the period of community supervision, conditions will be imposed on the defendant, and the defendant will be placed under a variety of programs. If the defendant is believed to have violated the conditions of community supervision, the defendant will be brought before the court. The court, after a hearing without a jury, will either continue or revoke the community supervision. If the court revokes the community supervision, the court will dispose of the case as if there had been no community supervision. It will sentence the defendant to a term of confinement not exceeding the term assessed by this jury. It may also require the defendant to pay any fine assessed by this jury that the jury recommended be suspended. The duration of the period of community supervision will be determined by the court. It may not be for a period of longer than 10 years. If you recommend that the defendant be placed on community supervision, the court must grant the defendant community supervision. In addition, if the defendant is granted community supervision, the court may impose any other reasonable condition that is designed to protect or restore the community, protect or restore the victim, or punish, rehabilitate, or restore the defendant. During the period of community supervision, the court may at any time alter or modify the conditions imposed on the defendant. If the defendant is placed on community supervision, the court will determine what conditions to impose on the defendant. You may recommend that the defendant be placed on community supervision only if both of two requirements are met. 1, the punishment you have assessed is not more than 10 years confinement, and 2, you find the defendant has never been convicted of a felony in this or any other state. If you decide to recommend that the defendant be placed on community supervision, you should indicate whether you recommend suspension of the term of confinement, any fine, or both. If you decide not to recommend that the court suspend the sentence and place the defendant on community supervision, you should use the verdict form that does not recommend community supervision. Specific law applicable to this case. You have found the defendant, Asa Joseph Jones, guilty of aggravated assault. This offense is punishable by 1, a term of imprisonment for no less than 5 years and no more than 99 years or for life, or 2, a term of imprisonment for no less than 5 years and no more than 99 years or for life and a fine of no more than $10,000. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, he will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed or 30 years, whichever is less. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant if he's sentenced to a term of imprisonment, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. And then that has my signature on it. And then you have actually 2 verdict sheets, and you'll obviously only pick one of those. The first one is titled Verdict, No Recommendation of Community Supervision. And it reads, we, the jury, having found the defendant, Asa Joseph Jones, guilty of the offense of aggravated assault, assess his punishment at. And then you have 4 choices, and you would only select one. The first, imprisonment in the Texas Department of Criminal Justice for a term of blank, 5 to 99 years, and no fine. The second, imprisonment in the Texas Department of Criminal Justice for a term of blank, 5 to 99 years, and a fine of blank, $10,000 or less. The third option, imprisonment in the Texas Department of Criminal Justice for life and no fine. And then the last is imprisonment in the Texas Department of Criminal Justice for life and a fine of blank, $10,000 or less. And again, that has a space for the signature and the printed name of the foreperson. And then the second verdict form is titled Verdict, Recommendation of Community Supervision. We, the jury, having found the defendant, Asa Joseph Jones, guilty of the offense of aggravated assault, assesses punishment at. And then you have 2 choices on this one. The first is imprisonment in the Texas Department of Criminal Justice for a term of blank, and it would have to be between 5 and 10 years and no fine. The second is imprisonment in the Texas Department of Criminal Justice for a term of blank, 5 to 10 years, and a fine of blank, $10,000 or less. And then it further reads, having assessed punishment at no more than 10 years imprisonment, we further find that the defendant has never been convicted of a felony and recommend he be placed on community supervision. We recommend suspension of, and then you'll pick out of the 3 following. The first, the term of imprisonment only. The second, any fine assessed only. And the third is the term of imprisonment and any fine assessed. And then again, that has the signature name for the signature line for the name of the foreperson. All right, Mr. Coleman, the state has the right to open and close closing arguments.
State waives this right to open, but reserve this right to close, Your Honor. The probation department, know you.
Yes.
We made an effort to make sure that that wasn't put out there during the guilt innocence phase so that it wasn't prejudicial to the defendant, right?
Correct.
All right. Nevertheless, this defendant was being supervised by the probation department back on June the 12th of 2025, correct?
Correct.
For the offense of unlawful carrying of a weapon, right?
Yes.
Please tell the ladies and gentlemen of the jury the nature of his compliance with or non-compliance with the conditions of his probation.
Your Honor, I am going to object because there was prior testimony, it is hearsay, that she was not his probation officer. She was a supervisor of a supervisor. So it's based on hearsay.
I can lay a little bit of a predicate if you'd like, Judge.
Sure, go ahead.
You were not the actual probation officer that supervised this defendant, correct?
Correct.
But nevertheless, is it part of the duties of each individual probation officer to make entries or what some of us old school lawyers and old school probation officers refer to as chronos, right?
Yes.
It's essentially like notes that are put into the system of the database
Yes.
about the defendant or about certain events or activities in their case, right?
Yes.
And have you reviewed the chronos as it relates to this particular defendant in his community supervision?
Yes.
Okay.
I'm sorry, again, I object. It's like a police report. Another officer cannot testify as to the information of the report. She testified earlier that she had no knowledge of Asa Jones and that was not her supervisor.
So these are business records maintained in the ordinary course of probation department's business.
I don't remember what exhibit that was, Judge. And again, I object even to the business records of her testifying as to somebody else's information.
Sustained.
One of the questions I'd like to answer is about whether or not his probation is extended. That's not hearsay. That's represented by a document, an actual document, Judge.
I'll allow that.
In this particular instance, was this defendant's probation extended?
Not in the case I talked about yesterday.
Was his probation or a previous probation ever extended?
Yes,
Typically under what circumstances? So he's had 2 probations, right?
correct.
Okay. Typically under what circumstances would a defendant's probation be extended?
Typically, it's to allow them additional time to be compliant with the terms of their probation. Mostly includes their court order fees, to give them additional time to pay court order fees and or community service or anything else particularly that hadn't been completed.
The records as it relates to the extension in that probation, what do those records indicate? Not what somebody entered into a system or notes that somebody put into a system. What does the actual document indicate was the reason for the extension? If you know.
Again, objection, Judge, same thing.
Sustained. If someone else entered it into the record, then it's hearsay.
Is it with regard to the probation the defendant was on during the commission of the offense, the aggravated assault that we're here on, was it a prohibition? Was it prohibited by his conditions of probation to not commit any other offense or violate any other laws of the state of Texas?
Yes,
And you are aware this jury has found this defendant guilty of aggravated assault, correct?
yes,
And that is a violation of the Texas law, correct?
correct,
And in turn, as such, it's a violation of his probation, correct?
correct.
That's what the judge.
Thank you. Any questions, Mr. Burbank?
I do.
Okay.
How long have you been a probation officer, ma'am?
Since 1998.
You have supervised or have you known individuals that have been on supervision for aggravated assault?
Yes,
As a person that is under probation, they're under a number of rules, correct?
correct,
And it's under the supervision of the court, but you supervise a probationer for the court. Is that?
Yes.
Did I say that right?
correct,
Court puts them on probation and then says you supervise them.
correct.
In that supervision, there are a number of regulations or rules that someone needs to abide by.
Yes,
Agree with me?
yes,
Couple pages long.
yes,
There's curfew.
yes,
There's no drinking of alcohol or drugs.
correct,
Staying away from certain people of bad reputations or things like that, right?
yes,
There's community service.
yes,
And felony community service usually is much more than misdemeanor, isn't it?
yeah, yes,
I mean, you're looking at several hundred hours of community service over the term. And misdemeanor is usually about 40 or 60, correct?
yes,
Sometimes.
yes,
Okay.
yes,
Now, the term of supervision, is it your understanding through your experience is that the jury in this case has found him guilty and they have to assess if he's qualified for probation to assess whether or not one is either going to sentence him to penitentiary time or TDC time or say I recommend probation, right?
yes,
From you. And one of the requirements, though, is that if they do decide to put him on probation, they cannot assess a term of more than 10 years incarceration.
correct.
Now, I want to talk about that a little bit through your experience. The term that they put on, and in this case, it's a first-degree felony, it's no less than 5 and no more than 10 years incarceration, right?
For probation,
For
Purposes,
probation.
yes.
If they assess that then they can go ahead and recommend to the court the assessment of probation, correct?
Yes,
Probation can be anywhere from, in this case, 5 years up to 10 years, correct?
correct.
But that is set by the court in reference to the length of time. Agree with me? They have to recommend it, but
Yes,
the court assesses the
yes,
length of time of probation.
yes,
Probation can be anywhere from 5 years to 10 years, right?
right,
And then subject to that, if he violates it within that period of time, then he's subject to whatever prison term they assess. For instance, if they assess 10 years and he violates any rules of probation, then he is looking up to 10 years in the penitentiary.
yes,
Okay. Just as if it's 5 years, and he violates it, he's only looking at up to 5 years, well, which is the minimum, but which is a bad example. But he's looking at up for 5 years, correct?
correct.
Okay. So it's important that if he is considered for probation, that the term of prison can't be assessed more than 10 years by a jury.
Correct.
Okay. Also, with the rules of probation, there are also programs, correct?
Correct.
That the court can assess or probation can assess, right?
Correct.
They can send them to an ISF program. What is ISF?
It's an intermediate sanction facility. We have two types. One is the cognitive track, which helps with their criminal thinking errors. And then we have another track that addresses substance use.
Substance abuse. So if he had a problem with drugs, for instance, if this case was a controlled substance and he had prior controlled substances, that may be a program to say, hey, you might have to do that.
Correct.
There's also safety in that too,
Yes.
which is a lockdown facility and a state jail facility.
Yes.
Correct? Okay. And that's usually done by an assessment by the probation department to see whether or not a person needs help.
Correct.
And then you said one of them was cognitive,
Yes.
and that's basically is you're going down the wrong path. You need to get straightened out.
Correct.
That's a program. Is it like a self-help program or was it a lockdown facility?
No, it's lockdown for
Lockdown?
yes, for 90 days.
And it could be whatever time, depends on how a person acts.
Correct.
If they abide by everything, it could be shortened or long, whatever it might be, correct?
I don't know about the shortened, but it can be extended.
It can be extended.
Yes.
And the purpose of that is saying you're getting your second chance or you're getting, you're not going to the penitentiary.
Correct.
So we're trying to help you make the right choices.
Yes.
I had also heard that, and I was wondering that probation also tries to help with employment.
Correct.
In fact, did you ever hear people that if they wanted to become a truck driver, they send them to LIT through some programs?
Yes.
Or processing or anything like that, trying to help them along, correct?
Correct.
And do you see that in your experience that sometimes employers don't want to take a chance with somebody on probation?
Yes.
And so you try to help them get over that hurdle and try to pick an employer that will give them a second chance?
Yes.
Through your experience, Ms. Roach, does a lot of the problems that probationers have is money, trying to get a job, maintain jobs,
Yes.
to try to get, I guess, back on their feet again and try to be productive?
Yes.
And have you seen that if that doesn't happen, they start running into problems, don't they?
Yes.
They have families and things like that.
Yes.
So there's a whole bunch of regulations and rules that if somebody is granted probation, that they would have to abide by over whatever period of time. In this case, no less than 5 or 10 years.
Correct.
Okay. If they violate, then does it usually come through the probation department? The violation?
Yes.
I mean, if they get arrested again for another offense, you get the police report, or you get notified by the jail, he's back in custody again.
Yes.
If he's not complying with community service or not going to the counseling or programs or whatever it might be, that's generated through your office.
Yes.
And then somewhere down the line, there's an administrative hearing,
Yes.
and then that recommendation is then sent to the judge.
Correct.
And when you send it to the judge, is that to determine whether or not they need to file a motion to revoke this
Yes.
person's probation?
Yes.
And then the judge says yes or no.
Correct.
The judge then puts him back usually in custody, either holds him in custody or lets him set a bond, but there's a hearing in front of this court.
Yes. Yes.
So if somebody is given probation, stands here and is given a second chance, and then he has to come back in front of this judge if he doesn't take advantage of that second chance.
Yes.
And this judge would have to decide what to do with the motion.
Yes.
Have you, in your experience, have you had probationers that have used deadly weapons on probation?
Yes.
Have you had probationers that have been given second chances, like 2 probations or so?
Yes.
Yes. Does it make a difference in reference to a probationer's age?
No.
And they would have to report how often?
It depends on what level of probation they would be on.
That's what I wanted to get to. There are different levels of probation.
Yes.
And what are the levels?
You have the low risk, a moderate risk, or a high risk.
Okay. And don't you have like a 0 tolerance too?
Yes.
Which is that what you call the high risk?
Yes.
Okay. Low risk is we think everyone's going to be compliant. The probationer is going to be compliant, and he may report or she may report once a month.
Correct.
Or as long and comply with either writing in or calling or doing whatever, and you think they're going to complete it.
Yes.
If you think that a probationer is going to maybe a little bit of a attention getter or you need to keep track of them. So then it kind of goes to medium high.
Yes.
Tell me a little bit about 0 tolerance through your experience in reference to probation.
0 tolerance is usually, the judge usually sets that, and mostly because they've been in front of her on some allegations, and his probation may be reinstated, and 0 tolerance means don't mess up. You do anything wrong, you're coming back to court, possibly facing going to prison.
I mean, it's like if you test dirty, it's a violation. I'm ordering you bring him back to court.
Yes.
If he doesn't show up, if he doesn't comply with community service or anything within your multitude of rules, it's 0 tolerance. You didn't do it. Back in front you go.
Yes.
And through your experience, have there been many people on 0 tolerance?
Yes.
Pass witness.
No further questions for Ms. Roach, Judge?
Thank you. Any objection to Ms. Roach being excused?
No.
Thank you, ma'am. Thanks. Mr. Coleman?
State calls Hunter Freeman or recalls Hunter Freeman.
And Mr. Freeman, you're still under oath from before.
Yes, ma'am.
Have a seat. Go ahead.
Thank you, Hunter. Thank you, Hunter, for coming back. Just for the record, state your full name, please.
Hunter Allen Carl Freeman.
You didn't want to be here this morning, did you?
No, sir.
In fact, you told me you didn't want to be here.
No, sir.
Why not?
It's a little hard to talk about sometimes.
What makes it hard?
Just everything, bringing it back up. Just after a whole year, you tend to kind of put it past you just a tad bit, or try to at least.
Have you been successful in putting it behind you?
No, sir, not really.
In what ways does this, what happened to you, affect you and your life?
It's hard to sleep sometimes. Constantly remember the gunshots and everything. You're hearing in my ears at least 3 or 4 times a day. I can't hear out of my left ear damn near at all. I still do have clear hearing, but it's muffled. You can just tell the difference between your left and right side. My teeth, they tell me I can never have a full set of teeth again, most likely. Not unless they do some side of more surgeries, and it's just, it's still hard to eat sometimes. Can't eat certain things, whatever, just because of how sensitive everything is.
And you understand this jury's task with assessing what they consider to be the appropriate punishment for this defendant for what he did to you. You understand that?
Yes, sir.
You understand they've got a really wide range to choose from, anywhere from letting this defendant walk out of this courtroom with a piece of paper and promises what they call probation, all the way up to 99 years of life in prison. You understand that's on the menu for this jury, correct?
Yes, sir.
Have you given some thought as to what you think justice would be and what you would ask this jury to assess in the way of punishment?
Yes, sir.
And what would that be?
Be 40 years, sir.
You don't reach that, or you didn't reach that conclusion lightly, did you?
No, sir, not really.
You gave it some thought?
Yes, sir.
Why do you say 40 years?
I don't want him to go to life forever. I don't want him to be in prison forever. Everyone makes mistakes, sir. I do understand that. But also what he did was wrong. And I just don't think he should be able to walk away from it either.
I mean, you've got to live with those memories for the rest of your life, right?
Yes, sir.
You've got to live with your hearing loss for the rest of your life, right?
Yes, sir.
And you've got to live with the issues with the loss of your teeth and not being able to enjoy food and a meal as a result of losing your teeth. You've got to live with those consequences for the rest of your life, correct?
Yes, sir.
That's the way it's changed.
Thank you. Any questions?
John. Again, good morning, Mr. Freeman.
Good morning.
40 years. Let me ask some questions.
Go ahead, sir.
Mr. Freeman, if you were sitting there and Asa was sitting there, and Asa was asked, what do you think the appropriate punishment might be? Okay. And Asa said 40 years. Okay. 40 years. How old are you?
23.
63 years old. And this is based on testimony yesterday from you that said, I caused it, right? You testified to that. So you have to answer.
Yes, sir.
I taunted him. Remember
Yes, sir.
saying that? I said, come on, do it.
He couldn't have heard that statement, no, but yes, sir.
But you said that,
Yes, sir.
okay? And you said, I wasn't going to back down because that's how I wasn't taught.
But I did back down, sir.
No, but did you testify to that?
Yes, sir.
Okay. And so with that being said, and that belief, 40 years,
Yes, sir.
some another individual that did that and said that, which was you, and he reacted to it.
Yes, sir.
Nothing further.
Mr. Coleman?
Hunter, are you on trial here today?
Yes, sir.
Sir,
Yes, sir.
Asa Jones is on trial for shooting you in the face, right?
Yes, sir.
Could you in any way on God's green earth have envisioned that when regardless of how that road rage began or started, or who cut who off first, is there any way you could have envisioned that this defendant would pull out a gun and shoot you in the face?
No, sir, because I had one on me myself, and I did not even think of even reaching for it.
Thank you. I'll pass.
Two last questions. This started approximately 2 to 3 miles before an actual shooting. That's what the testimony indicates, right?
Yes, sir.
So for 2 or 3 miles, you had a chance not to cause it, not to taunt him.
So did he, sir.
Okay. Not to taunt him. And not to just stay there because no one was going to do that to you. Right?
Yes, sir.
Believe in what you said and what happened.
Yes, sir.
We talked a little bit, and did we talk about that we may not agree with the jury in the decision,
Yes, sir.
but just as I told you, do you agree that you respect their decision because that's what we asked them to do?
Yes, sir.
Okay. And that's like life, isn't it?
Yes, sir.
Sometimes people agree, it's easy, and sometimes it gets difficult, doesn't it?
Yes, sir.
Right now, you're in a difficult part, aren't you?
Yes, sir.
They're going to decide what to do with you. We heard testimony from your mom that how old were you when you were shot while you were sleeping in your bed?
Maybe like 20.
20? So you didn't even know what was going on.
No, sir.
And when you shot once or twice,
Twice.
did it cause fear?
Yes, sir.
Were those people ever arrested?
No, sir.
Did you wish they were arrested?
Yes.
Okay. During this period of time, your mom said you were employed.
Yes, sir.
And what she said in reference to what you were talking about, what she was talking about in places that you worked, is that true?
Yes, sir.
And that you always work.
Yes, sir.
And you worked starting at 15.
Yes, sir.
And you helped your family out?
Yes, sir.
Okay. When you were working, why were you working?
Why was I working?
Yeah, why were you working?
Help my mom, really. Yeah, I really didn't much care about having money. I just really wanted to help my mom.
Well, you're 27?
Yes, sir.
Do you ever dream?
Dream?
Yeah, dream.
Yes, sir.
You ever dream of what you might want to be when you're?
Yes, sir.
I mean, you're getting old, not as old as me, but you're getting old.
Yes.
What do you want to be? What did you want to be?
What I wanted to be?
Yeah.
Growing up, basketball coach, something like that.
You like sports?
Yes, sir.
Want to be a basketball coach? Right? How about working?
Working?
I guess basketball coach is working.
Yeah, but as far as working, it really didn't matter what I did. I just like to work just so I can help my mom, no matter what it was.
Help family.
Basically.
Tell me about your 2 kids. How old are they?
6 and 7.
And the 7-year-old's name?
Chloe.
All right. And the 6-year-old's name?
Lakin.
When you had kids, I guess you were kind of young, 20 years old, 21 years old?
Yes, sir.
How did that make you feel?
I just wanted to be a part of their life because I never had a dad. So,
How did you take it when you heard that you were going to be a dad?
I was excited.
You were young.
Yeah. Yes, sir.
You didn't finish high school.
No, sir.
One of the things, if the court was to consider probation, you're going to have to finish high school. I can tell you that's probably going to be a requirement.
Yes, sir. I was in the process of getting my GED though.
You were?
Yeah.
How
Yes, sir.
far are you away from it?
Well, I was in the process.
Okay.
But
Was this before you were put in jail?
yes, sir.
So when do you think that would have happened? Would you have gotten it?
Yes, sir. Most definitely.
Okay. And why did you think that a high school diploma was a good thing?
high school diploma.
Yeah, graduating from
That's
high school, a
that-
GED. Why is that a good thing?
That's just something important that you like a achievement that you should want to achieve in your life.
You want to be somebody.
Yes, sir.
You think it would open up doors?
Yes, sir.
After you got high school, if you got a GED, would you have tried to go on to either college or some type of processing 2 year or something to even better yourself more?
Yes, sir.
You have 2 girls. You've been in some minor stuff, misdemeanors, marijuana and guns and stuff like that. What kind of example do you think you are to them sitting in county jail, not being a part of their life?
That's a bad example. It's like I made a promise to my daughter that I'd never leave her side, and I broke that bond by making a huge mistake in my life,
During questioning yesterday in reference to when Mr. Coleman was asking you questions, one is that are you sorry for what happened?
Yes, sir, 100%.
You still believe in what happened and what you testified.
Yes, sir.
You're not changing the story.
No, sir.
Are you sorry of the outcome?
Yes, I am.
But you really didn't know what the outcome was going to be at the time you did it, did you?
No, sir.
But you know it's kind of stupid afterthought.
Yes, sir.
Did you ever intend to hit Mr. Freeman?
Not at all.
But you realize when you fire a gun,
it's a possibility.
Yeah. So I guess the question would be, and I would anticipate possibly the question once I sit down is, one of your daughters was traveling down East Texas Freeway. Somebody came alongside them, road rage or not, back and forth, wanting to cause it or taunt them. And they shot. Went through one side and out the other. Now we're sitting here in front of the jury in reference to punishment. The person who did it, sitting here. What punishment do you give that person?
I mean, honestly, in my honest opinion, I feel like some people just deserve a second chance. People make mistakes in their life. Some people just need a second chance to better themselves. See how to say this. No matter the circumstance, some people just need a second chance to reflect on what they did to know, like, well, I don't want to go back down this road, and I know what the outcome would be if I do this, so I don't want to make that mistake again in my life.
I know when I sit down, here's some of the questions I anticipate you're going to ask or are going to be asked. Starting back in 2016, excuse me. You were arrested for UCW, right?
Yes, sir.
Given a year's probation. Why didn't you learn your lesson then? I know it's just a misdemeanor, and now you're in the big times. This is a felony, a first degree. You're looking at up to life in the penitentiary. Why didn't you learn that?
I wouldn't necessarily I didn't learn. It's just with my house being shot up like that, I feared for my safety. I just wanted to protect myself and my younger sister and my mom. So I don't know who shot me and why my house was targeted. So I wouldn't necessarily say I didn't learn because I did learn from it. And them charges, it's really not just. I just was in possession of a gun. I never committed a crime or anything like that. So, but I did learn from my mistakes. I learned from all my mistakes.
Carrying a gun is a crime.
Yeah, it is a
You're
crime.
convicted of it.
It is.
So back in August, you had a couple of them, which were the same time. Possession, I believe. UCWs. How come you didn't learn then? I know it was another misdemeanor. How come you didn't learn then?
I wouldn't necessarily say I didn't learn. I just was in fear. I was for my safety wise, just overall safety wise.
And when this happened back in June 12th, 25, you were on probation.
Yes, sir.
You were under the rules. You heard Miss Roach. She wasn't your probation officer. You were under the rules. Right?
Yes, sir.
Second chance. Let me ask you this, Asa, and it may seem simple. When you left downtown on the 12th and were heading back up north of Tram Road, was it your intention to get into road rage?
Not at all.
Was it an intention to pull out your gun and if you feared for your safety or not feared for your safety or whatever, to shoot?
No, was my intentions.
It happened in the heat of what was going on.
Yes, sir.
Did you realize that if you were 5 minutes or a minute before or after, this probably you wouldn't even sit here?
Say it all the time. I say 10 seconds.
If this jury was to consider probation, there's going to be an awful lot of rules and regulations, okay?
Yes,
In
sir.
reference to this. Do you think you can do it?
Yes, sir.
You were on probation when this happened,
Yes, sir.
okay? But now, instead of getting your 30 days or 50 days if you violated it or 180 days, whatever it is, you'll be looking at up to 10 years in the penitentiary.
Yes, sir.
Who in your family went to the penitentiary?
Uncles, cousins.
What'd they go to the penitentiary for?
I'm not sure on the charges, but just know they
How long have they been in?
years.
Huh?
Years. At a time.
Years? You look up to them?
Yes, sir.
Well, how do you look
I
up
did.
to them when they're sitting in TDC?
Well, at a point of time, I did.
You want to have a cell with your uncles?
Have a cell with them?
Yeah, have a cell.
No, sir.
Be in the same unit.
No, sir.
You think that maybe you could correct this?
Yes, sir. I'm all about breaking on generational curses.
Generational curse.
Not a curse, but like a
How about-
recycle thing. Like, you know,
How about breaking your bad decisions so that you don't take the white bus to Huntsville?
that as well.
You asking this court or this jury to consider probation?
Yes, I am.
And you realize that if you do violate it, you'd be here, and this judge has listened to this testimony.
Yes, sir.
And do you know what the outcome would be if you violated, if they determined to give you probation? Do you want to take odds of what the outcome would be?
Up to what the case holds.
Yeah, you want to take a bet now if they were to give you probation? Let me answer it for you. 10 years. Not even a consideration. You realize that?
Yes, sir.
What have you done in the last 10 years in your life? How many birthday parties have you gone to?
Quite a few.
Christmases,
Quite a few.
4th of July's. We just did 4th of July.
Many.
You realize that if you were in the penitentiary for 10 years, these are everyday things?
Yes, sir.
And to Mr. Freeman, are you sorry?
I am very regretful. I'm just glad he's alive and he's okay today. Sincerely, from my heart, I do apologize for what happened.
Pass witness.
Thank you, Mr. Coleman.
Thank you, Your Honor. Just got a few questions for you, Mr. Jones. Maybe we can just kind of get through this as quickly as possible. Are you saying to this jury that the fact that you grew up without a father, the fact that you've been shot before, Those are the reasons why you shot Hunter Freeman back in June of 2025.
No, sir, that's not the reason why.
Okay, thank you. All right, are you saying that this jury should feel more sorry for you than they do for Hunter Freeman?
Not at all.
Okay. You don't have any issues with your hearing, do you?
No, sir.
You don't have any issues with your teeth, do you?
No, sir.
But you understand that Hunter Freeman would have those issues for the rest of his life, right?
Yes, sir.
All right. Now, you have been convicted, albeit of misdemeanors. I will concede they were misdemeanors of 3 separate unlawfully carrying of a weapon. Let's start with the first one in 2016, I believe it was. No, 22. You had 2 of those in 2022. The first one in 2022, what kind of weapon was it? What kind of gun was it?
A handgun.
Do you remember the brand? Was it a Glock or?
I don't remember the brand.
Okay. This handgun, where'd you get it from?
Out the streets.
Who did you get it from off the streets?
I don't recall.
Because you used that term yesterday. I mean, I'm a little baffled by this term off the streets. I mean, you're telling me like Dowling just pops up a gun, or Concord pops up a gun and gives it to you? Or are you saying that there's an individual in the neighborhood that provides you with the gun? Is that what you're saying?
It's an individual. I just don't recall who.
Okay. Let me ask you about that second UCW, that second possession of a firearm in 2022. What type of gun was that?
A handgun.
Do you remember the brand?
No, sir.
Did the streets give you that one too?
Yes, sir.
You don't recall who gave you that one?
Not at all.
All right, let's move on to the 2024 unlawful carrying of a weapon. You know the question I'm going to ask. Where did it come from?
Streets, and I don't recall who I got it from.
That's unfortunate. That is very unfortunate that you don't recall any of that. Let's move on. You understand that you have, by the decisions that you've made, put yourself and by virtue of those decisions, your daughters in this situation to where they might not be able to see you. You understand?
Yes, sir.
I mean, there is an element of personal responsibility. You would agree, right?
Yes, sir.
I mean, once you become an adult, we're all kind of accountable for our decisions that we make and the consequences. Wouldn't you agree?
Yes, sir.
Your attorney, Mr. Burbank, characterized your actions that day as, quote, and I wrote it down, kind of stupid. I think I would beg to differ with that. Shooting a vehicle no less than 6 times as it's moving down the highway. Let me ask you this. Did you know if there was a baby, a child, a kid in the backseat of that Suburban when you fired off 6 shots at it? Did you know if there were?
No, sir.
Could have been, could have.
Yes, sir.
You could have killed a kid as well, in addition to shooting Hunter Freeman, right? This is not how this works. Your attorney can ask you follow-up questions if he chooses to.
Yes.
But you could have killed a kid that day, in addition to shooting Hunter Freeman, right?
Yes, sir.
Those bullets could have ricocheted off or went through that Suburban and hit oncoming traffic. Wouldn't you agree?
Yes, sir.
Hunter Freeman could have become incapacitated, lost consciousness, and veered into oncoming traffic or hit another vehicle. Wouldn't you agree? Yes or no? Wouldn't you agree?
Yes, sir.
Okay. Again, Mr. Burbank can ask you all the follow-up questions he wants to ask you.
No, I'm going to object to the sidebar remark.
Overruled. Go ahead.
You asked for a second chance, your words. But you would agree with me that you already had a second chance. In fact, you've had a third chance when you received that first probation and the second probation. Wouldn't you agree? Yes or no? You've had at least 2 prior chances before coming in here asking this jury for probation. Yes or no?
Yes, but not a violent.
Excuse me, non-responsive judge. You are not asked the judge.
Just answer the question.
Can I say
this?
anything?
No. This is how it works. Mr. Burbank can get up in just a minute and follow up on any of these questions with any explanations. Okay, it'll just be easier if you answer it how it is. Mr. Burbank can stand back up and ask you questions. Okay.
You understand those are the rules of court, right?
What's the rules?
What's
Just ask questions.
That's my question.
Yes.
You understand my
Ask
question?
the question that has to do with this.
Well, I'm going to tie in. Just give me one more
Okay.
question. I'll tie in.
Go
You
ahead.
understand those are the rules of this
Yes,
court?
sir.
And you understand that there were rules in the jail that you had to follow too, is right?
Yes, sir.
Did you follow the rules in jail?
I did.
By throwing urine on another inmate that you didn't break the rules?
It wasn't urine.
Yes or no? By throwing it, well, let me ask, okay, even if it wasn't, by throwing another substance on another inmate.
I got gas first.
Listen, Mr. Jones.
It's not justifying my answer. I'm just saying. He asked me a question that comes with explanation. Like, it's a yes or no.
Listen to the rules. Again, right now in court, listen to the rules. The rules are answer his question. If there's an explanation, your attorney can stand up, ask you for an explanation, and you can give that explanation. That's the third time I've told you, yesterday and now today twice.
Thank you. You didn't follow the rules regardless of what you threw on that other inmate, did you?
I follow the rules in jail.
And that's what you want this jury to believe.
I do.
Okay. You also said that you've learned and reflected on your mistakes. Is that what you want this jury to believe?
Yes, I do.
And this jury will make the determination as to whether or not you can follow the rules. Because probation, you would agree with me, has rules, right?
Yes, sir.
And you violated the rules of your most recent probation by committing aggravated assault, correct?
Yes, sir.
All right. That's the witness, Your Honor.
Thank you. Mr. Burbank?
Asa, when you were trying to explain in reference to the jail, did you have
After nearly a decade on probation, Malik Ellis stood just one mistake away from losing everything. Judge Raquel West didn't hold back. She reminded him that she could revoke his probation immediately and send him to prison for up to 20 years. Marijuana might not seem like a big deal to some people, she said, but while you're on probation, every violation matters. Ellis admitted he made a mistake, but the judge pointed out he'd already tested positive multiple times. More than anything, she wanted him to take responsibility instead of making excuses. Then came the surprise. Instead of revoking his probation, Judge West gave him one final opportunity. She extended probation for 1 more year, ordered stricter supervision, frequent drug testing, and mandatory MRT classes. Her message couldn't have been clearer. Follow every rule for the next year, and you walk away without a felony conviction. Slip up again, and you're going to prison. Sometimes, mercy comes with one last warning, and no second chances after that.